So, Malas, you say to hell with the 10th schedule. It gives me an escape route. I'll ignore it. I'll go to the 3 steps. And the language, without opening it, Malas, without opening it, where his original political party merges with another political party, and he claims and any other members of the original political party have become members of such political party, or as the case may be, of a new political party formed by such merger. Well, this is directly snooking a nose at the 10th schedule, which is a constitutional creation. It is, well, I'm sorry to use colloquial, it's actually saying, look, to hell with the 10th schedule, we have made this 3-step procedure. Why on earth could you not recontest, resign, merge, or the 4th one? Condonation, I'm not getting into, that's another one. Go to the Election Commission and file a complaint then. On 21st, instead of Surat and Guwahati, why did you not file the Election Commission? So this is the first answer. This is one of the best answer at least I can give to the direct question, but there is a consequential answer further ahead. I'm putting it against myself and trying to answer, because I put this question to myself and Lordship asked it yesterday. Now, Malas, a possible argument will be twofold. That is no argument, because Malas, how it works in actual law, a fact is not an argument against me. If the law is a prohibitive and a affirmative, then you jolly well follow it. That's the object of creating a constitution. But now I'm giving an answer against me, even though it doesn't arise in law. The answer is, what happens, Mr. Singhvi, if between me, that is they, applying to the EC and doing these things which Mr. Singhvi is advising them to do, the speaker disqualifies you? I'm putting it bluntly against myself. Wallace, first answer is, so what? Why was the 10th schedule created, Wallace? Is the speaker doing something unknown to law? But there's a better answer. If he disqualifies you, there is full judicial, this is on the basis wrongly. There is full judicial review. No, but you can't, Wallace, your lordships can't find a solution to everything which the Constituent Assembly, the Constituent amending people did not make. What is this answer that what do? I will be disqualified? Well, jolly well you'll be disqualified because the 1985 framers gave this power to the speaker. Is the possibility of an abuse ever the test of the power or its existence? Was can it be? Otherwise, how will your lordship decide anything? Yes, that phrase comes from Rajan versus Indira Gandhi. Possibility of abuse is not the test of power. Give that citation.
Hindustan judgment. Hindustan construction, some judgment is there.
Also Hindustan construction.
Abuse of power cannot be there.
Your lordship should judge everything. Oh, what will happen? What may happen? But that's not the question. Here, and your lordship is talking of lesser cases. Here the constitution was amended to give this power. And the apprehension is, I will not go on 21st to speaker, to EC. I will go to Guwahati because I'm scared of a disqualification. Now, let us look at the second. I'm giving a lot of extreme examples against myself. You have a full review possible. My review is much more truncated. It takes 1 year for me to get this hearing before your lordships. Your review is immediate on a wrongful decision against the speaker. And your lordship knows Kyoto says, after final decision of the speaker, you will get a stay of that. You can't get a stay while he's deciding. You can get it afterwards. Of the disqualification also. Only a quia tibet is stopped.
You're comparing that with what?
With the fact that if you don't do this and stay and make the 10th schedule a dead letter and install a new government on the basis of ignoring the 10th schedule, that is much less reversible by sheer passage of a few days than your right to challenge. Today, what is the whole argument? It's a scrambled dead, it's a fake accompli. Your lordships can't reverse it. It's 1 year down the line. That's the real argument today. That's the argument we are facing. Now let me give your lordship another bizarre example against myself. These are not normal examples. Whereas I don't know of, except a very few number of cases, where you have the courage of conviction to resign and recontest. That resignation is impeded. It happens. There are 2 or 3 judgments we have. But normally, let me assume against myself that I resign because of my high standards and my resignation is not accepted by the speaker. That's the worst I can assume against myself,
Right.
I can't assume something more than that, Again, the speaker can only reject my resignation and disqualify me. He cannot do anything more. The speaker cannot say that you shall do this or that. He'll at the most say, I reject your resignation and I disqualify you. Same remedy. That remedy, your lordship will stay in 2 seconds. Suppose your lordship had an MLA who resigned to fight a new election, and the speaker, there may be bizarre cases, I don't know, speaker said, no, I disqualify you. How long will it take a court to give a stay of that order? I mean, your lordship is dealing with these cases on and off every day, in some form or the other. But here, none of these 4 or 5 possibilities is allowed to be tried, because you adopt a 3-step procedure to annihilate the 10th schedule. Which brings us to the harmonization principle. I'm not going to cite law about harmonization. From ordinary petty contracts to constitutional law, your lordship's first principle is harmonization. From statutory, delegated legislation up to the constitution. Whereas I want to make the different point here that why did the 10th schedule come? We'll read Mr. Ashok Sen's speech in when he piloted this 85 thing. The whole purpose is that you have come through a party seat, you go and face the electorate again, whether with that party, independent or a third party. That's the whole long and short of this. Have your lordship ever heard this happening except in some very rare cases in England or other democracies? There's no concept, I've come on a party, I'll either resign or I'll just leave that and fight again from another party. That was the whole purpose of this. But what you are telling the court is that no, I will affirmatively not resign. I will not go to the EC. Why? Because I'm scared that somebody will disqualify me. But then what was Mr. Ashok Sen enacting in 1985? He's enacting a power of disqualification for changing a party. What is the purpose of 2/3 of parliament saying so if you can simply...
What is the harmonization principle that you're referring to?
Harmonization is this 4-fold, 5 originally with the faction, otherwise 4, are the flexibility, play in the joints, affirmative permissibility part of the 10th schedule. And the 2(1)A, 2(1)B is the negative prohibitory part. You can do all these 4 without doing the negative part. For the negative, you don't have to violate the negative part for any of these 4. I will say, even if you go to the election commission, you don't have to violate a whip. You don't have to voluntarily give up your party. You say, I'm on principle, please decide this.
So in other words, you are saying, other than those 5 instances,
4 now.
Everything else falls within the net of 10th schedule.
And one more thing I'm saying, that 10th schedule, absolutely correct. And the 10th schedule has both parts. It has those 4, it has a negative. It creates a whole code by itself. Harmonization means that your lordship will adopt my submission and interpretation because it harmonizes the negative and the positive. Now for 30 seconds, see if your lordship does not adopt the harmonization principle. The only thing a lordship will have to validate is a 3-step procedure. There's nothing else, it's staring a lordship in the face. The 3-step procedure, I want to ask myself, in which case will the 10th schedule bite? Let's be very blunt. What your lordship will do is your lordship's domain. But today, your lordship's other option, other than my option, which I am submitting most humbly and respectfully, is adopt the 3-step procedure or validate it or recognize it. But then how will 10th schedule apply? It cannot. And then, your lordships would be actually adopting an interpretation which reduces the 10th schedule to vanishing point. Actually vanishes, that's vanishing point, it vanishes. Every case of defection, I will say, I'll not resign. I won't go to the EC. I won't merge. Merger is given to you by the para 4 of the 10th schedule. I will not do it. But, as your lordships was told, I am the party, I am the overwhelming majority, I am the main person, I am it. I am it. Therefore, to hell with the 10th schedule. So, on principles of interpretation and much more so of constitutional interpretation than even statutory, this is a much better way to look at it than the contrary view. Because your lordship gives meaning to both sides and your lordship does not adopt something. What is this other adoption which is propounded to your lordships? On the high moral principle of democracy, dissent, free speech. Each of my 4 options gives you that option. So what the 10th schedule does is, it says, I am giving you a free speech option. I am giving you a democracy option, but within my own terms. I am not giving you a jungle Raj free speech and democracy option. Otherwise, why would I enact a 10th schedule?
See, but merger, Dr. Singhvi, was not an option open to them because they were not claiming to merge their party with either the BJP or any other party.
With respect, I'm sorry to interrupt, my lords. Why not?
So, merger was not an option.
No, it was an option. They did not choose to exercise it.
You're right, you're right.
That's correct.
It's an option.
They chose not to exercise an option.
In the abstract, but they were not following the merger route at all because it's not their case that, look, this part of the Sena
That's exactly
has
my point.
merged with another party. That is not
That's
clear.
exactly my point with greatest
Then
humility.
the only point is that in a situation like this, where they say that we have lost faith with the leader of the party,
Yes.
then the only option according to them, according to you, is that you resign and recontest.
No. I will stick to my 4 options.
That's
I'll say all the 4 options are available.
No. What do they do then?
No. Whereas resign is one.
Right.
These 9 people will merge with another political party. Why not? But the fact that I don't exercise an option
That is not an option because merger means that their political identity as the Shiv Sena is lost then.
Well, then in that case, if the 10th schedule says that I recognize only this path of exit from this room, you can't say I'll make a new tunnel to get out.
But you know, Dr. Singh,
He can't
this
make a
part
new-
of your argument is a problematic argument.
problematic.
I'll tell you why. Because your argument postulates that if you have a dissension, then the only way you can express the dissension is to leave the party and merge somewhere else.
One.
They say, sorry, we don't want to leave. I mean,
Right.
ideologically, I am a Shiv Sena man. I don't want to leave, he says. He says, I don't want to leave the party.
So as per
Kindly
your
see, Bharat,
argument,
now kindly see the consequences of it.
even if somebody applies to the election commission at
Yes.
the initial stage instead of in the legislative assembly,
Correct.
and says that we now want the political party to
That we are the
accept us
political party,
as-
recognize us.
So even that, according to your argument, is impermissible then.
No. Because
So because that's outside the
so long as
5 instances that you have given,
No. One of my 5 is EC.
he's not resigned.
I beg your pardon. No. One is resignation, one is split, which is gone now, one is merger. The 4th is EC.